Well, we're grateful to everybody for their submissions on the first issue as we have defined it. Very clear and very helpful submissions from everyone. We've considered them carefully and we have decided that we are not going to make a reference to the Court of Justice of the European Union. We think it to be act clair that Jersey is a third country for this purpose. That means that the two remaining questions are, firstly, what does Article 56/Article 63 actually require in relation to a third country such as Jersey? And secondly, what are the implications of those requirements for the interpretation of the domestic statute? And I think it's over to you now, Mr. Steinberg.
It is indeed.
Yes.
So I propose to deal with what we've called issue B first. I'm entirely in the hands of the court as whether you would like that to be dealt with, as it were, separately, or with, we've rather anticipated I will deal with all the remaining issues together, and sort of worked out a timetable now to take in our submissions on that basis.
Let me just pick up. Now you call issue B.
Issue B is the domestic law issue.
Sorry?
That's the domestic law issue. Issue B.
Where does one find issue B defined?
Oh, I'm so sorry. That's in the Statement of Facts and Issues, which you'll find...
80 to 81.
That's...
Page 84.
That's the position irrespective of the application of EU law.
Yes.
Well, that's the last thing we want to hear about.
Ah.
Yeah.
Is that...
Yes, we're not in, subject to what may be said. I'm not sure it's going to be terribly helpful to us to know what the House of Lords said in the 1940s about the domestic law. The issue is how should this legislation be interpreted so as to conform with the requirements of Article 63.
I entirely understand that. I had anticipated, perhaps wrongly, and it makes no difference what I anticipated, that one only got to the EU aspect of the matter if...
It's the other way round, Mr. Steinfeld. You only get to the Dreyfus aspect of the matter, if I can call it that,
yes.
If you don't read the language of the statute in accordance with its plain meaning, yes. If that conforms with EU law.
Well, in accordance with its plain meaning, if you don't add the Dreyfus restriction, or as we've called it, the Dreyfus plus restriction, then there doesn't appear to be very much argument, because quite plainly, the residuary estate of Mrs. Coulter was subjected to be held on trust for purposes which HMRC accept are charitable purposes under English law. There's no dispute about that. The dispute was whether...
That's a conforming interpretation.
Well, that was...
Well, I don't know.
Yes, that is a conforming...
We're trying to look at this through the eyes
yes.
of the present day, yes. Which are not the same eyes as 1940, where yes. We're having to interpret in a way which conforms.
Yes.
You're saying the ordinary meaning of the word does conform.
Yes. What I propose to do, if that is acceptable to the court...
No, we've all read Dreyfus. Yes. We've all seen what that says. So
is to take, if I can put it this way, your lordship's, ladyship's lead on this by looking at the statutory provision passed in 1984 and first asking the question, looking at that statutory provision, did Parliament actually intend that provision to mean anything other than what it says, which is that a gift qualifies for charitable exemption from inheritance tax if, as a result of the gift, and the gift could be by will or inter vivos, the property, using the second limb, becomes held on trust for charitable purposes only. The suggestion, of course, has been that those words should have some different meaning, not trust as it's generally understood, which can apply to foreign trusts, but restricted to trusts governed by English law. That's what the Court of Appeal held in its first decision. That's why they went on to...
Yes, but I mean, it was split up between them, so they had to deal with it that way.
Yes.
We happily don't. We're able to look at the thing around.
Well, obviously the starting point must be to look at the language of the statute in the context of the statute and see whether the words in section 23.6, or prima facie at any event, to be read as at what they say, trust for charitable purposes only, including foreign trust. So what I'd like to do there is take your lordship first to the legislation itself, which seems to be a good start. That's in volume 1 of the authorities bundle. I'll give your lordship the electronic number in just one moment. It starts, at page 355. And I'm going to take you first, if I might, to the section itself, which is at page 370. Which we've all looked at and you've seen, obviously, any time. Transfers value exempt to the extent the values transferred by them are attributable to property which is given to charities. Charities is defined later for the purposes of the Act, but for the purposes of this section, the expression property is given to charities is, as you can see, they're given an extended meaning. Obviously, property is given to charities, it becomes the property of charities. That's the nature of a gift. But Parliament goes on to say, or is held on trust for charitable purposes only. Now, the suggestion is, I'll put it no higher than that charities, which is defined in the Act at section 272, which you'll find at page 394, electronic. Charity and charitable have the same meanings as in the Income Tax Acts. And we know, I'll take you to the provisions if you want to see them again, that charity has been defined in successive Income Tax Acts as being a body of persons or trust established for charitable purposes only. But of course, what we're interested in is not those words, but the words upon trust for charitable purposes only. We respectfully submit that there is no reason why those words should not be given their ordinary meaning as a matter of English. A trust can include, and indeed under the Act can include, a trust which is governed by a law other than the law of the United Kingdom. We can see that very clearly if you look at section 43, page 373. The following provisions of this section apply for determining what is to be taken for the purposes of this Act to be a settlement, and what property is accordingly referred to as property comprised in a settlement or as settled property. Settlement means any disposition or dispositions of property, however affected, whereby the property is for the time being, and then the use of the expressions held in trust, etc., held in trust to accumulate with discretion, and then the words or would be so held or charge or burden if the dispositions or dispositions were regulated by the law of any part of the United Kingdom, or whereby under the law of any other country, the administration of the property is for the time being governed by provisions equivalent in effect to those which would apply if the property was so held. Just pausing there, and I don't know whether the courts noticed this, but that is almost mirroring the observations of Lord Normand in the Dreyfus case, when he took exception. One exception he did take, and one of his brethren agreed with him on that. The others made no comment one way or the other. But he said, well, the expression trust isn't necessarily to be confined to an English law trust. It can be extended to mean any other arrangement under common law which has a similar effect. I take it to that if you want to see it. We'll see it in a moment. But in any event, you can see here that the expression trust is being expressly extended to include trusts under foreign law systems.
There's no definition of trust, is there?
There's no definition of trust in the Act, no.
There's a definition of trustee. Does that
Yes.
help us?
No, I don't think it does.
Not in here.
Have a look. I think we did look this one up, so we may not have the relevant legislation here. Yes. Yes. But what we do have, what you see is a settled property. Settled property is property held in trust. Now, if we go to Section 58, and there are numbers of these, and the first one, which in our submission makes my point entirely, Section 58(1), in this chapter, relevant property means settled property. So going back, we know settled property means property which can be settled on a foreign trust, in which no qualifying interest in possession subsists other than property held for charitable purposes only. So it's talking about property held for charitable purposes only under a settlement. The point is made perhaps even clearer if you go to Section 76(1). Tax shall not be charged under this chapter. So again, we're dealing with settled property under potentially foreign trusts. Ceases to be relevant property, i.e. an interest in possession comes to an end. So it's still settled, or ceases to be property to which various other sections apply, on becoming, and then property held for charitable purposes only. So there's the legislature using that self-same expression as in Section 23(6), but to describe property which is held on a potentially foreign trust for charitable purposes only, and essentially giving to those the same exemptions for charitable gifts as you get on a straightforward transfer of value on death or inter vivos. Then we get the same Section 84. For the purposes of this chapter, where the trusts on which, this is on page 385, on which settled property is held require part of the income of the property to be applied for charitable purposes, there you go. Part of the property of a settled property, i.e. settled on trusts which could include foreign trusts, is under this section regarded as potentially held to be applied for charitable purposes only, under a foreign trust. A corresponding part of the settled property shall be regarded as held for charitable purposes. Then we get Section 86, trusts for the benefit of employees. That's over at page 386. Where settled property is held on trusts, which, either indefinitely or till the end of the period, do not permit any of the settled property to be applied otherwise than for the benefit of, and then various classes of persons are set out, essentially employees, then subject to subsection 3, this section applies to the settled property, or as case may be applies to it during that period. It's basically an exemption which applies where the property is held for the benefit of employees. Where settled, then subsection 2, where settled property is held on trust permitting the property to be applied for the benefit of persons within A and B, those trusts shall not be regarded as outside the description period in that subsection by reason only that they also permit the settled property to be applied for charitable purposes. So again, the legislature is talking in terms of a relaxation of the taxing regime to cater for provisions in potentially foreign law settlements which provide that the whole or part of that property is to be held for charitable purposes only. Now, the Court of Appeal, in their first decision, was rather dismissive of those, although it didn't actually, I think, go through the provisions in quite the way that I'm taking this court through them. But what you can see, and that's why I use this as my introduction to what I call the EU aspects of the matter, is that on its ordinary meaning, Section 23(6), second limb, is perfectly capable of extending to foreign trusts. Not capable of extending, but it seems that the legislature assumed that you could have a trust for charitable purposes which benefited from the exemptions for charity, but put into but as part of a settlement which expressly could be governed by foreign law.
Where the second limb of 23(6), which is what we're talking about now,
Yes.
where does that first appear in the tax legislation then? Because it's not obviously covered by the Dreyfus case in
I
terms.
think this is the first time, the first limb,
Yes,
I think this is the only time it appears.
the second limb.
The second limb, I think this is the first time that the second limb appears, but I'll check on that from my learned junior who's much more versed on tax matters, I have to say, than I am. But I think that, yes, I think this is Section 23(6) is the first property given to charity's first limb, and I think the second limb or becomes the property, it was held on trust. I think that's the first time it's introduced. And of course the reason is that in this group of sections they're talking about the basic charges and what I call the basic exemptions. In the parts that I was reading to your lordships, your ladyship, the sections are dealing with a more nuanced state where it's part of a settlement and part of the settled property is to be held on trust for charitable purposes only, and extending to that part the same or similar relief that you would get on what I call a straight outright gift to charity.
Mr. Steinfeld, I think you may be going a little fast for me.
I'm so sorry. I'll slow down.
Can I just try to be clear about the sort of the unstated so far premises of your argument? Am I right in thinking you're proceeding on the basis that in order to conform to Article 63, the exemption for gifts to charities has to operate in a way which does not discriminate between UK trusts and foreign trusts? Is that it?
That is the basic one, yes.
So you're not pushing the idea. I mean, what Article 63 prohibits is restrictions on the movement of capital.
Yes.
You're happy with restrictions, provided the same restrictions operate internally.
Well, the way I think Article 63 or Article 56 has been interpreted, I shall of course take your lordship to the correct number of authorities,
Yep.
but a provision under domestic law under which an exemption for tax, and some of them are charitable exemptions, some of them are tax advantages, is extended to persons who are resident within the member state's territory, but to no one else, is on its face regarded as a restriction on the free movement of capital, because it deters people in one member state from investing either in another member state or in a third country.
So it's discriminatory taxation,
Yes.
where discrimination is based on whether the treatment applies internally within the UK in a more favourable way than the way it applies to movements of capital outside the UK.
Yes.
And
See, that was why I was suggesting at the outset that it would help us to know what the requirements of Article 56/63 are before we start looking at the domestic provision.
Well, I'm quite happy to do that. What I shall do then, if I might, is take the court through the EU authorities.
And can I just flag up, before you do that, the second point I was going to ask about, which is your focus on the second leg of Section 23(6),
Yes.
funds held on charitable trusts. I would have thought the argument must apply in exactly the same way to the first leg of gifts to charities.
It does, indeed. But for my purposes, I only have to satisfy you on the second limb. The first purpose that gives to charities, where, as you've seen from our argument, the reference is to established charitable institutions, one can see on that a need potentially for some form of supervision of that charity, because quite apart from anything else, the exemption is applied to charities as defined for income tax purposes. And under the Income Tax Acts, a charity as so defined is entitled to exemption on income earned on investments in the United Kingdom, so far as that income is applied for charitable purposes. So HMRC have to be satisfied, not just that the institution is eligible for relief on income tax, but that it is actually applied its income for income tax purposes. Now, I accept slightly different considerations may apply there. I don't have to go so far for the purposes of this appeal, necessarily, unless your lordship want me to, into that limb, because we rely on the second limb, whatever may be the true ambit of the first limb. But I think if I might say, in answer to your lordship is right, that in principle,
And the point you've just made rather emphasises the importance of working out what EU law actually requires, because if, for example, EU law requires us, for the purposes of Article 63, to have a particular definition of, and a particular understanding of Section 23, it may not necessarily be the same one as applies for the purposes of the Income Tax Acts.
Well, that's right. And Parliament has here, this is the difficulty which we've said in our written case, Parliament, of a conforming interpretation, Parliament here has not chosen to give a separate definition to charity for the purposes of inheritance tax, but to adopt the same definition as for income tax. And you only get really to the sort of conforming interpretation if you can squeeze your conforming interpretation so as to deal with all the range of taxes.
Well, not necessarily. If the income tax definition was not compatible with EU, if when translated it across to Article 6 to movement of capital, it wasn't compatible with Article 63, you just disapply it. You disapply the provision that says the charitable, Section 272, you disapply that definition.
Well, I suppose you could disapply the definition, but then you really are indulging in legislation, as it were.
It isn't indulging, it's what we're required to do.
That's been law since...
It's a bad word, and I take back that word. Then the court...
So could we please concentrate, to begin with, on what the requirements of Article 56/63 are, and then go on to see how they do or do not fit in with the UK legislative scheme.
Yes. Just in summary, therefore, Article 56, now Article 63, provides for the free movement of capital, not just between member states, but between member states and third countries. Any provision in domestic law which has the effect of inhibiting the transfer of capital either between member states or member states in a third country is therefore, on the face of it, an infringement of those provisions, infringement of EU law. An inhibition can be, or a restriction, sorry, I should have said, that has been held to apply specifically to domestic legislation which confers a tax advantage which is restricted to persons seated or resident in the member state and not elsewhere. It has been further specifically applied to provisions that grant charitable exemption, but only to charities established within the state. There can be no doubt, as I'll show you the court in a moment, and indeed it seems to be accepted, that what we've referred to as the Dreyfus restriction, which would read this legislation, in particular Limb 1, as referring only to charities established within the United Kingdom, that falls foul of, when I say falls foul, that is on prima facie an infringement of the right, freedom of movement of capital. Both with excluding charitable institutions in another member state or charitable institutions in a third country. I'll take the court to the authorities that established this. There is an exception to the freedom of movement of capital, which you will have seen allows a state to derogate, a member state in its legislation, from that principle for the purposes, it is being said, a number of purposes in the general interest, and one of the purposes has been what's called guaranteeing effectual fiscal supervision, EFS. However, as the authorities, which I will show you, establish, you are only permitted to derogate in that way from the principle of freedom of movement of capital if, in regard to the extension of a tax advantage, which is what we're dealing with here, if there are conditions attached to that advantage which need to be verified by the authorities of the other state, and in the case of third countries, if by reason of the absence of a treaty between that third state and the member state for the exchange of information or the giving of assistance, it has proved impossible to verify that that condition has been fulfilled. That, in our submission, is the thread that runs through all the EU cases, to which I will now come. If I could just give you a rundown of the cases which I shall be coming to, which all illustrate the point that I'm making. The first is Stauffer, which I'll be taking you to. It's in volume 225 at page 2008. Yes, manuscript 2008. So, I'm so sorry, 1029. It was decided in 2008.
That sounds more like it. 2008 was far too big a number.
Yes, I was misreading my notes. I do.
1029.
Followed the following year by Scatterverket and A, which is at 226 at 1059. Followed in the same year by Persha at 327, page 1098. Followed a year later by a case called Rambo, which is at volume 3, tab 28, at 1136. Followed by Haribo in 2011, which is at volume 3, tab 29, electronic 1161. And then we have Velta at 331, page 1265. Emerging markets at 332. I think it's I think it's 1327 actually is a part in the judgment that I'll be taking you to. Cecil at 333. I'll be taking you to passages at 387 onwards, 1387 onwards. 1349, sorry, and 1387. 1349.
1349.
And then the very latest, hot off the press, X, and I'm afraid I don't know the German pronunciation for GmbH, but I'm sure others do.
Gesellschaft mit beschränkter Haftung.
Yeah.
I'll just call it X. I'm very grateful to your ladyship. And that was a judgment that came out, I think it was the 16th of February, which is, I think, like a day after we had found out the case in this matter. And that's at 338 1490. So if I go back to Stauffer, and I shall take, if I might, I shall take this court as quickly as I can. What I aim to do is direct your lordships and your ladyship to passages which would bear reading, but I shall emphasise the particular passages that fortify the points that I've been making. So that's at volume 2, at page 25, to tab 25. That's 1029. Just to summarise the facts there, under German law, there was granted an exemption for corporation tax to bodies which pursued charitable purposes. But that did not apply, in effect, to bodies situate outside of Germany. The question was whether that provision fell foul of EU law as constituting a restriction of free movement of capital. The taxpayer which complained that it did was a charitable foundation established in Italy. It was accepted by the German authorities that its purposes were wholly charitable under German law. But the German authorities relied on EFS to justify the restriction. If I could take you first of all to page 1048. Which is in the Advocate General's opinion. Under the heading, the lack of adequate means of supervision and verification. Tax Office and German government supported in this respect by the government of the United Kingdom. Chief State Solicitor of Ireland suggests that German authorities do not have adequate means of supervision and verification with regard to foreign foundations. Problems may arise in particular because the German fiscal administration may not restrict the verification only to the foundation's activity that is relevant for tax purposes, but must, in order to establish the foundation's acquired and retained charitable status, be able to conduct a thorough check on all the foundation's activities. The practical difficulties accompanying a thorough verification of foundations that pursue cross-border activities cannot be denied. The necessity, indeed the indispensability of such means of supervision and verification are undisputed in light of growing concerns over public safety. However, this argument fails to recognise that in the main proceedings, the Bundesfinanzhof does not express any doubts as to the foundation's charitable status, and therefore evidently takes the view that the German financial authorities' means of verification are sufficient. That, if I might say so, that observation, of course, applies to our case. HMRC did not express any doubts as to the charitable status, if I can use that expression, of the bequests in Mrs. Coulter's will. They say they're fully satisfied that it, as it were, satisfies the conditions in section 23, which include, incidentally, an important condition. They have to be satisfied, I didn't take you to it, under section 23.5, that the assets, the property, will at all times only be applied for charitable purposes. That's subsection 5, if you just want to look at that condition. And what the Advocate General says, in any case, however, the above-mentioned difficulties concern the recognition of charitable status foundations with seat abroad and do not justify for tax purposes any discrimination against foundations whose charitable status is not in doubt. As a result, the exclusion of charitable foundations with limited tax liability from tax exemption cannot be justified on grounds of effective fiscal supervision either. If I can go to the judgment, paragraph 27 is at page 1054. The fact the tax exemption for rental income applies only to charitable foundations, which in principle have unlimited tax liability in Germany, places foundations whose seats are in another member state at a disadvantage and may constitute an obstacle to the free movement of capital and payment. It follows from the above that legislation such as that at issue in the main proceedings constitutes a restriction on the free movement of capital, which is in principle prohibited by the treaty. It is necessary, however, to consider whether such a restriction may be justified in the light of the provisions of the treaty. And if you go to paragraph 40 at page 1055, nevertheless, it goes, the fact remains that where a foundation recognised as having charitable status in one member state also satisfies the requirements imposed for that purpose by the law of another member state, and where its object is to promote the very same interests of the general public, which it is a matter for the national authorities of that other state, including the courts, to determine, the authorities of that member state cannot deny that foundation the right to equal treatment solely on the ground that is not established in its territory. Now, I hope that that answers, I think, Lord Reed's question to me, the outset, what is it that is prohibited by the right to freedom of movement of capital? This is, I think, the first case we've had, but it's repeated in all the other authorities. It's providing discrimination, I think was the word my Lord used, and that mirrors the words that's used in this judgment. If you discriminate against foreign entities, that distorts the movement of capital and therefore, or could distort the movement of capital and therefore is on the face of it a restriction. So it's therefore a breach of the principle of freedom of movement of capital.
And the discrimination consists, looking at this,
Yes.
in the failure to grant an exemption from tax to a foundation whose object would be recognised as qualifying it for an exemption under national law, under the law of a member state.
Absolutely. That's exactly, in our submission, what the court is here saying. And that's made clear, paragraph 42. Accordingly, in circumstances, those in the main proceedings, the effect of the legislation is to treat foundations in objectively comparable situations differently by reason of their place of residence. It follows that such a fiscal measure cannot, in principle, constitute unequal treatment permitted under the article unless it can be justified by overriding reasons in the general interest. In order to justify the difference in treatment between charitable foundations with unlimited tax liability in Germany and those that are not established there, arguments have gone before the court relating inter alia to promotion of culture, to training with education, to effective fiscal supervision and various other things. We're only, I think, concerned in this case with effective fiscal supervision. And I think if you go down to paragraph 46, secondly, various governments maintain that the tax legislation at issue in the dispute in the main proceedings is justified, firstly, by the difficulty of ascertaining whether and to what extent a charitable foundation which is established abroad actually fulfills the objects laid down in its statutes in accordance with national law, and secondly, by the need to monitor the effective management of that foundation. The court has on many occasions held that effectiveness of fiscal supervision constitutes an overriding requirement of general interest capable of justifying a restriction on the exercise of the fundamental freedoms guaranteed by the treaty. And then paragraph 48, thus before granting a foundation tax exemption, a member state is authorised to apply measures enabling it to ascertain in a clear and precise manner whether the foundation meets the conditions imposed by national law in order to be entitled to the exemption, and to monitor its effective management, for example, by requiring the submission of annual accounts and an activity report. Admittedly, where foundations are established in another member state, it may prove more difficult to carry out the necessary checks. Nevertheless, these are disadvantages of purely administrative nature, which is not sufficient to justify refusal on the part of the authorities of the state concerned to grant such foundations the same tax exemptions as are granted to foundations of the same kind, which in principle have unlimited tax. And then makes a point in 49, nothing to prevent the next tax authorities from requiring the charitable foundation claiming exemption to provide evidence to enable the authorities to carry out the necessary checks. Now, it goes on further, national legislation which absolutely prevents the taxpayer from submitting such evidence cannot be justified in the name of effectiveness of fiscal supervision. I'll come back to that because it's suggested that there is a significant difference between here, the relationship between member states and where the transaction in question involves a third country, which is not a member state. I'll come back because that's dealt with in the authorities later on. So that's Stauffer. If we can go to Skatteverket, which is the next authority. That wasn't a charity case, but it involved another tax advantage. It's at page 1059 in the electronic version. That case, Swedish legislation granted exemption from tax in respect of dividends distributed in the shares of a subsidiary, but denied that exemption where the distribution was made by a company established in a third country outside the EEA, unless it was party to an exchange of information treaty with Sweden. The complaint was by a Swedish taxpayer in respect of dividends distributed by a Swedish taxpayer in respect of dividends distributed by a Swiss company. There was an exchange of information treaty with Switzerland, but it was very limited and did not, so it was said, enable all the verifications to be obtained. And the issue was whether that restriction fell foul of EU law. If you could go first to page 1081. Where the Advocate General says, like the Skatteverket and the intervening governments, I am of the opinion that the restriction may be justified by the need to guarantee the effectiveness of fiscal supervision. A basis on the following grounds: I'm aware that the need to guarantee the effectiveness of fiscal supervision constitutes an overriding requirement of general interest capable of justifying restriction of the movement of capital. This justification may also be linked to Article 58, which refers to measures taken by member states to prevent infringements of national law and regulations. However, in order for the restriction to be justified, it is necessary, according to case law, for the national measure in question to be suitable for the purposes of attaining the objective pursued, but it must not go beyond what is necessary to attain it in accordance with the principle of national proportionality. That, you will see, is a thread that runs through all the EU cases, which I'll be taking you to.
But that's standard proportionality analysis.
That's what I say.
That's standard proportionality analysis. It's not limited to
Yes.
this context.
No, it's any tax advantage, which includes a tax exemption for charity, and we'll see lots of other tax exemptions, or cases where impositions of tax are being imposed on a discriminatory basis. And the Advocate General goes on to say, 128, the question at the centre of the present case is therefore whether the limitation at issue in the main proceedings is proportionate for purposes of attaining that objective. And then he says that it's made out, and that, he says, is made out that for the following reasons. Sorry, I should say 129. More specifically, that question arises because the exclusion from the exemption of profits distributed by a company established in a third country, which has not concluded a convention with Sweden that provides for exchange of information, absolutely prevents the taxpayer receiving dividends from those companies from submitting evidence that the conditions laid down in Swedish law met. The question is therefore whether such an exclusion, based on the premise, it's important to look at that evidence supplied by the taxpayer cannot be checked with the competent authorities the country has established, can be regarded as proportionate. So the question was referred to the court on a premise that there was no way of obtaining necessary information. He said, I consider for the following reasons this premise is indeed made out in the present case. And he gives his reasons. And it's clear, he says, from the documents and explanations provided by the Swedish government, that the only information which can be obtained from Swiss authorities under the agreements is that needed to ensure proper application of the convention. However, since the Skattenemnden considered, on the contrary, that it is possible under the arrangements to obtain the information needed to check compliance with conditions laid down in Swedish law, it will be for the National Court to verify this point. The assumption, therefore, that the premise that the evidence supplied by the taxpayer cannot be checked with competent Swiss authorities is well-founded. I'm of the view the exclusion issue in the main proceedings must be regarded as proportionate for the following two reasons. And he sets them out. First, it's impossible for the member state to obtain competent authorities information needed to check the evidence supplied by the taxpayer. Moreover, since that taxpayer knows that such evidence cannot be checked, the member state concerned faces an increased likelihood that its legislation will be infringed. Now, the court, if you could go to page 1094. I think I can take it up at paragraph 56, 55 perhaps, at 1094. Under Article 58, Article 56 is without prejudice the right of a member state to take all requisite measures to prevent infringements of national law and regulations, particularly in the field of taxation. The court thus recognised the need to guarantee the effectiveness of fiscal supervision constitutes an overriding requirement of general interest capable of justifying a restriction on the exercise of freedom of movement guaranteed by the treaty. 56, a restrictive measure to be justified must comply with the principle of proportionality, in that it must be appropriate for securing the attainment of the objective it pursues and must not go beyond what is necessary to attain it. According to A and the Commission, the legislation at issue in the main proceedings is disproportionate for the purposes of securing the objective pursued, since the Swedish tax authority can require the taxpayer to furnish proof the requirements for entitlement exemption provided for by that legislation are satisfied. And then, as 58, as A and the Commission pointed out, with regard to national legislation restricting the exercise of one of the freedoms of movement guaranteed by the treaty, the court has held the member state cannot rely on the fact that it may be impossible to seek cooperation from another member state in conducting inquiries or collecting information in order to justify a refusal to grant a tax advantage. Further down at 59, in that context, the court has held the taxpayer should not be precluded, a priori, from providing relevant documentary evidence, enabling tax authorities of the member state imposing the tax to ascertain clearly and precisely that he is not attempting to avoid or evade the payment of taxes. And then 60, however, that case law which relates to restrictions on the exercise of freedom of movement within the community cannot be transposed in its entirety to movements of capital between member states and countries, since such movements take place in a different legal context from that of the cases which gave rise to judgments referred to in the preceding paragraph, and then sets out the reasons. And then at paragraph 63 comes what we would respectfully submit, a passage repeated in subsequent cases, and sets out, actually, what is or what can be read into national legislation, the most that can be read into national legislation, to make it compliant with EU law. It follows that where the legislation of a member state makes the grant of a tax advantage dependent on satisfying requirements, compliance with which can be verified only by obtaining information from the competent authorities of the third countries, it is in principle legitimate for that member state to refuse to grant that advantage if, in particular, incidentally in a later authority you'll see those words in particular have been transposed to if, for example, so whether that was what was meant, I don't know, because that third country is not under any contractual obligation to provide information, it proves impossible to obtain such information from that country. Now we'll see that cited again and again in all the authorities, and that in our submission spells out what you can read into legislation, if necessary, to make it compliant. The most that you can read in. So the conditions that need to be satisfied, as you can see there are two conditions. One is that the grant of the advantage is dependent on satisfying the requirements, compliance with which can only be verified by obtaining information from the competent authorities of a third country. And secondly, that because that third country is not under any contractual obligation to provide that information, it proves impossible to obtain such information from that country. And so the answer to the question at the bottom, page 67, the answer to the question must be that articles are to be interpreted as not precluding the legislation of a member state which provides exemption from income tax in respect of dividends distributed in the form of shares, may be granted only if the distributing company is established in a state within the EA or the state with which a taxation convention provided for the exchange has been concluded by the member state imposing tax, where the exemption is subject to conditions compliance with which can be verified by the competent authorities of that state only by obtaining information from the state of establishment of the distributing company. Now, just pausing there, self-evidently, the satisfaction of any condition, the conditions attached to exemption under certainly the second limb of section 23.6, and maybe also, though that's not directly our concern, the first limb as well, it's not subject to conditions compliance with which can be verified by the UK only by obtaining information from Jersey, because we know as a fact that they have, well, quite apart from the lack of any spelling out of what the conditions are that need to be verified, I'll come to that, we know as a fact that in this case, they have been able to satisfy themselves perfectly well that this is a true gift which satisfies the conditions of section 20, otherwise satisfies the conditions of 23.6, without having to obtain any information from Jersey, from competent authorities of Jersey. So could I go on now to Persia, which is at volume 3, and it's tab 271098. That's another income tax case. No, it's a charity case, sorry. German law granted, as we've seen before, exemption from income tax of gifts made to charities, but only if the charity was resident in Germany. The taxpayer made a donation in goods rather than in money, though I don't think, although that was a point that they had to consider, I don't think anything about that is relevant for the present case, made a donation to charity in Portugal, but was denied the deduction. The question was whether the German legislation fell foul of EU law, and if we take up the Advocate General first of all, at paragraph 59, which is at 1112. And in addition, it says the United Kingdom argues that gifts to national bodies and those to bodies situated in another member state are not comparable in the sense that first member states may apply different concepts of welfare and different requirements for the recognition of charitable status. And secondly, a member state can itself check compliance with those requirements only in the case of national bodies. The Advocate General says these arguments are not persuasive, particularly having regard to the lessons flowing from the judgment in Stauffer. And at paragraph 62 over the page, to accept that member states have a discretion when determining the general interest they wish to promote, and to refuse the automatic application of mutual recognition of the bodies recognised as charitable in the different member states does not, contrary to what the United Kingdom appears to claim, solve the problem of the objective comparability between the situations of bodies established, admittedly in different member states, which have as their objective, and this is not disputed in the main proceedings, the promotion of the same general interests, in this case, the welfare of children and elderly people. I think if you cut out the reference to children and talk about elderly people, you have the exact equivalent in this case. Though, admittedly, we're not another member state, but the observations of the Advocate General there were not, although he talks, because the case did involve another member state, Portugal, but would seem to be of general application. The only difference between being another member state and being a third country is what provisions, as a matter of proportionality, it would be appropriate to include in your legislation. Less provisions in another member state because, as between member states, under the treaty there is, and various directives under the treaty, there is an obligation of member states to cooperate with each other in regard to fiscal matters. If I could go to 77, where the Advocate General deals with the justification relating to the need to ensure fiscal supervision. In the interest of time, I'm not going to read the whole of that. You may want to read it to yourselves either now or at a later stage.
Do all these cases add anything to the point you got from Stauffer and Scattervirket?
I would be quite happy to stop if that was accepted by HMRC, but I think you need to see that this is not just an authority out of the blue. It is a consistent thread in all the authorities. I take your lordship's impatience.
Persia is a Grand Chamber decision.
Yes, it is. And Persia was actually the decision that led to a change in English law. The Finance Act 2010 changed the definition of charities as a direct result of Persia. But we don't accept that the change made the law compliant. It made it less non-compliant than it was before. I'll go quickly through these. I do understand my Lord Khan was impatient on the point.
My colleague.
But I'm sympathetic, if I might say so, with that. If you go to paragraph 86, even if it is conceded that it is more difficult to obtain the cooperation of a body established in another member state, since that body is not itself partially subject to tax in the member state in which the tax advantage is claimed, an absolute refusal to afford the donor the opportunity to produce at the very least proof relating to the statutes and effective management of the foreign body on the ground that, as a general rule, such a donor does not have that information, is disproportionate to the objective which the German tax measure seeks to achieve. Indeed, I consider it cannot be ruled out a priori that the donor is able to provide relevant documentary evidence enabling the German tax authorities to ascertain clearly and precisely that the foreign body complies with the conditions laid down in the statutes and with those relating to its effective management imposed by the national legislation concerning the recognition of the charitable status of non-profit making bodies. It's also difficult to accept the argument by, in particular, the United Kingdom. Looks like the United Kingdom has been very active in this field, that any check on charitable bodies established in other member states would be impossible, or at least involve a disproportionate administrative burden. So the exclusion of tax advantage at issue in the present case is the only appropriate measure for guaranteeing the effectiveness of fiscal supervision. Difficult to deny that, according to the taxpayers of one member state, the right to deduct donations which they make to charitable bodies established in other member states is likely to involve an increase in the administrative burden on the tax authorities of the former member state in their task of verifying whether the foreign bodies concerned satisfy the conditions laid down by the national legislation. It's also likely that such a right will lead to a consequent adjustment in the administrative practices which have, and until now, focused essentially on purely internal situations. However, I do not think the effectiveness of fiscal supervision would be jeopardised if the member states had to authorise such a right in order to comply with community law. And furthermore, if the verification of the status and effective management of the body has to be carried out, apparent from the documents before the court, So in the case of bodies established in Germany, documentary checks are usually sufficient. And it gives examples of what that involves. I therefore consider that according to the same tax treatment to gifts to foreign bodies recognised as charitable in their member state of establishments gifts made to national bodies, the objectively comparables should not impose a disproportionate administrative burden on the tax authorities. Admittedly, maybe that irrespective of the type of check to be carried out, tax authorities, donors, member state will need at least initially the assistance in some cases, competent authorities of the member state, unless their own information or the documentary evidence provided by the donor, with where appropriate, the collaboration of the recipient body is sufficient. And just another observation, again, paragraph 97, he says, at letter E, it should also be stated, that's page 1119, it should also be stated that, of course, to the mutual assistance provided by the directed in such circumstances does not, of course, affect the powers of tax authorities of the donor's member state to assess in particular whether the conditions to which the legislation of that member state subjects the deduction of a donation are fulfilled. And that, if you might say so, we could say, well, look here at section 23, subsection 5. The HMRC is entitled to withhold the tax exemption if it is not satisfied that the property, or if it is satisfied that the property may be applied for non-charitable purposes. May become applicable, I think is the word used, for non-charitable purposes. Yes, I just, the exact words. If it or any part of it may become applicable for purposes other than charitable purposes. Thank you. And then goes, however, it's important that the court has, that 99 has already held that a member state cannot rely on the fact that it may be impossible to seek cooperation from another member state, conduct inquiries or collecting information in order to justify refusal to grant a tax advantage, since those authorities are entitled to request from the taxpayer the evidence that they consider they need to effect a correct assessment of the tax concerned. And then at 101, and an automatic refusal to allow the tax deduction sought without allowing the donor to produce evidence that the foreign recipient body recognised as charitable in the member state may satisfy the conditions imposed by German law relating to the object set out in the statute, seems to me disproportionate in relation to the aim of guaranteeing the effectiveness of fiscal supervision. Now, I was going to go on to the judgment.
Well, paragraph 99 looks rather important from your
Oh,
purposes.
have I did tell you to read the whole lot. Yes, I've just read paragraph 99.
You have read it.
Yes, sorry, yes. It is important. It's very important in our submission. And basically it says, well, it goes back to what I highlighted to you before, taken from Skatteverket, is like the model legislation, the most that you can do. If there are conditions that require to be satisfied, which need to have verification from the competent authorities of a foreign state, and it's not just, and there is no agreement, but by reason of the absence of such agreement, you find it impossible for that to be done. So the first thing is there has to be conditions attached to the grant of the exemption which need to be verified. Now, there may be, in some cases, and that's the most the HMRC has said, that it can envisage circumstances, all of them, well, in fact, one circumstance it says that it envisaged is that it may need to check that the gift has been properly effected. That's an odd submission. You may have seen it in their written case, because, of course, it then goes, the HMRC then go on, in answer to our final issue in relation to the timing, to say, oh, yes, but this has all got to be judged as at the date of, in case of a gift by will, as at the date of death. So what happens afterwards doesn't seem to be relevant to the existence of the exemption. But if it is at all relevant, doesn't say why that has to be something that can only, in every case, and can only be done by getting information from, in this case, Jersey. The question is, what should the legislation apply to? And I think Lord Reid, if I might respectfully say so, got the point right on. That the question here is, what can these restrictions apply to? And the real question for this court is, can they apply here so as to deny charitable status to the admittedly, subject to the points made by HMRC, the admittedly charitable donation contained in Mrs. Coulter's will? So coming on to the judgment itself, you'll see the questions that have been asked at page 1128, paragraph 31. I won't read that, I think, to yourself. And then paragraph 38, as the Advocate General pointed out, since the possibility of obtaining a deduction for tax purposes can have a significant influence on the donor's attitude, the inability in Germany to deduct gifts to bodies recognised as charitable, if they are established in other member states, is likely to affect the willingness of German taxpayers to make gifts for their benefit. Such legislation constitutes, therefore, a restriction on the free movement of capital, prohibited as a rule by Article 56. And then just further down, paragraph 41, in order to be justified, the difference in treatment must not go beyond what is necessary in order to obtain the objective of the legislation in question. And if you go over to page 1131, paragraph 52, the need to guarantee the effectiveness of fiscal supervision constitutes an overriding reason in the public interest capable of justifying restriction. However, for a restrictive measure to be justified, it must comply with the principle of proportionality, in that it must be appropriate for securing the attainment of the objective it pursues and must not go beyond what is necessary to attain it. And in the next paragraph, the court has decided the possibility cannot be excluded a priori. The taxpayer is able to provide relevant documentary evidence, enabling the tax authorities of the member state of taxation to ascertain the nature and genuineness of the expenditure carried out in another state. Nothing would prevent the tax authorities concerned from requiring the taxpayer to provide such proof as they may consider necessary in order to determine whether the conditions, and I can translate that here, for under section 23.5 have been met, and consequently whether to allow the charitable exemption. And I go on to paragraph 69. It makes the same point. If it proves difficult to verify the information provided by the taxpayer, nothing prevents the tax authorities concerned refusing the deduction applied for if the evidence that they consider they need to effect a correct assessment of tax is not supplied. And then as regards charitable bodies in a non-member state, it must be added that it is, as a rule, legitimate for the member state of taxation to refuse to grant such tax advantage if, in particular, we've got exactly the same words as we've seen before, that non-member country is not under an international obligation to provide information. It proves impossible to obtain the necessary information from that country. So that was Persia. Followed the other authorities, made exactly the same points that I've already made to you, making good the point I'm making. Chronologically, the next case is Rambo. Rambo was concerned with the legitimacy under EU law of under French law, legitimacy of a provision of French law which imposed an annual tax of 3% on the value of any property held in France, but provided that the tax did not apply to persons with a seat in a state which had concluded a treaty with France for the administrative assistance. And the purpose of that legislation was plainly, as had been accepted actually in an earlier decision of the court, a case called Elisa. I can give you the reference to that in a moment, some years earlier. The purpose of that legislation was to combat French taxpayers from avoiding or evading payment of an annual wealth tax on property held by them in France by putting property into the name of a company which was outside of France. It was a tax avoidance evasion measure. But the question was whether the imposition of that tax on an exemption on a corporation established in Liechtenstein, which had not concluded any such treaty with France, fell foul of EU law. Just looking at what the Advocate General said at page 1147, and he starts a passage at paragraph 44. Again, I won't read the whole passage, but if you go to paragraph 51, the main issue in the present case is whether the difference between EU member states and the EEA countries is such as to justify a difference in the treatment applied by national legislation to taxpayers in other EU member states as compared with those in the EEA countries. Although ELISA, that was the earlier case I mentioned to you, is concerned only with that was the same tax, but there the question was whether it applied to a corporation that had been established in another member state. It's concerned only with relations between EU member states. The question arises whether the approach followed in that judgment also applies to relations between EU member states and the EEA countries, or whether the latter are to be assimilated to other third countries. And he says there are two aspects. ELISA, by the way, is at volume 5, at tab 65 and electronic 2101. I'm not going to take the court to it unless you feel that you would like to see it. There are two aspects of the ELISA case. The first aspect concerns the possibility, based on the principle of proportionality, that the taxpayer could make up for the absence of a formal framework for cooperation by providing information directly to the tax authorities. Second aspect concerns the importance to be attached to the existence of such a formal framework in EU legislation. I have some reservations about extending the scope of ELISA, in that the judgment envisages the possibility of replacing the mechanisms laid down for cooperation between the tax authorities with documentary evidence provided by the taxpayer. And then going down to paragraph 55, furthermore, in a tax system founded on the principle of legality, the tax authorities cannot refuse to take into account information supplied by a taxpayer without giving reasons for such a refusal. Since it seems inconceivable the court would have wished to grant such discretion to the tax authorities, it might be asked what criteria those authorities might use in order to determine information is insufficient, and that it is therefore necessary to produce the additional documentary evidence referred to in ELISA, if by definition they are unable to verify the accuracy of the information concerned in the absence of any tax cooperation arrangement with the state concerned. And his proposal, paragraph 58, nonetheless, I cannot propose the court's interpretation of that judgment be extended to cover relations with other third countries, since from the standpoint of the principle of proportionality, there's no material difference to my mind between the situation of taxpayers resident in these two categories of country. The Commission seems to be suggesting that proportionality test does not apply to EEA countries in situations where there is no adequate information exchange agreement with the EEA country concerned. If we go to the judgment, and I would take up the judgment at page 1158, just at the bottom of the page. In the case before the referring court, the French tax authorities are unable to obtain from the tax authorities of the Principality of Liechtenstein the information needed to exercise effective supervision of the information provided by the companies liable for payment of the tax in dispute. It follows that where the legislation of a member state makes the grant of a tax advantage dependent on satisfying requirements, compliance with which can be verified, and then basically the same principle we've seen before, and then it proves impossible to obtain such information from that country. So again, the two conditions. And then as regards the question whether the French tax authorities should, as the Commission maintains, conduct a case-by-case assessment of the information, should be noted apparent from ELISA in the context of the European Union, a categorical refusal to grant a tax advantage is not satisfied, as there is no reason why the French authorities could not call upon the taxpayer to produce the evidence they consider necessary for correct assessment of the taxes and duties concerned, and as the case may be, refuse the exemption applied for if that evidence in those is not forthcoming. Then it goes on, that case law does not apply, however, to the different situation of a company established in Liechtenstein, and then it considers the different regulatory framework in Liechtenstein. In that, and goes on, paragraph 59, court goes on, in that regulatory framework, the possibility acknowledged in ELISA that the taxpayer can produce evidence which the French tax authorities must consider, thus emerges a measure intended to prevent the limit which, through the application of Article 8, has been imposed by the general system of the exchange of information from acting to the detriment of the taxpayer. Although, therefore, that possibility is based on the existence of a general system of exchange of information, the existence of a right of that kind cannot be recognised in the case of a taxpayer in circumstances such as those of the case before the referring court, which are characterised by the lack of any obligation on the tax authorities of the principle of Liechtenstein to lend assistance. That had been found as a question of fact in that case, that there had been no cooperation from Liechtenstein. And then the court goes on, in those circumstances, legislation such as that at issue in the main proceedings, which you will recall is legislation actually aimed at preventing improper tax avoidance or evasion, must be regarded as justified vis-à-vis a country which is party to the EEA agreement for overriding reasons relating to the general interest in combating tax evasion and the need to safeguard the effectiveness of fiscal supervision, and as appropriate to ensuring the attainment of the objective pursued without going beyond what is necessary to obtain that objective. It follows from the foregoing that Article 40 of the EEA agreement does not preclude national legislation such as that at issue in the main proceedings, which exempts from the disputed tax companies which have their seat in a member state of the European Union, and which in respect of a company which has its seat in the territory of an EEA country, not a member state of the Union, makes that exemption conditional either on the existence of convention or on administrative assistance between the members and non-member states for the purpose of combating tax evasion and avoidance, or on the fact that pursuant to a treaty containing a clause prohibiting discrimination on grounds of nationality, those legal persons must not be taxed more heavily than companies established in that member state. Now, our submission in relation to Rambo is that of course turned on the facts of the case. The facts of the case were that the taxing, you had a tax which was designed to prevent tax evasion and tax avoidance by deterring French taxpayers from putting their assets into companies outside of France, and therefore imposing this annual tax on those companies. And that was justified because of the fact that the French authorities, and this was the premise upon which that judgment was made, as we can see, the French authorities had confirmed that they'd had no cooperation from Liechtenstein. They couldn't expect any cooperation from Liechtenstein to discover whether there was any legitimate reason for those companies holding that property other than to enable a French taxpayer to avoid or evade payment of wealth tax. Could I go now to Haribo? At the next divider, 29, page 1161. And that was a case where the Austrian law provided for exemptions in relation to distributions of profits from subsidiary to the holding company, and then from the holding company to the shareholders. It allowed for exemptions. It complicated how it did that, and I don't think your court is concerned with the way it was done, but it was to avoid what they call economic double taxation, i.e. the Austrian shareholder or company having to pay twice on the same profits, once when it's taxed in the country of the subsidiary and once when it's taxed in Austria. But that legislation did not apply, at least in its entirety, from dividends from a foreign subsidiary. And the question was whether that infringed EU law. The Advocate General, at page 1184, he deals with the restriction at paragraph 79 to 83. I'm so sorry, have I?
You might have got a gender problem there.
Yes.
Oh, I'm so sorry.
Madame Cocotte.
Yes, my learned junior had reminded me of that. Well, masculine includes the feminine by the Interpretation Act.
And vice versa.
And vice versa, indeed. The Advocate General at page 1184 describes the restrictions, and at paragraph 82 makes the point the effect of such legislation is to discourage corporations established in Austria from investing their capital in the form of portfolio holdings in corporations established in the EEA states. This is the case at least where there is no agreement with regard to administrative matters enforcement, as it is the case in relation to Iceland and Liechtenstein, according to since those dividends from those holdings receive less favourable treatment than dividends distributed by a national corporation that are less attractive to corporations established in Austria than national portfolio holdings. Justification, he then deals with, I shall just go on to paragraph 88 at page 1186. Even if there is therefore no comparability for restrictive measure, the restrictive measure in question must, however, comply with the principle of proportionality. It must be appropriate for scoring the attainment of the objective it pursues and must not go beyond what is necessary to attain it. Consideration must again be given to whether the criterion of the objective being pursued in a convenient and systematic manner may be of relevance. And then paragraph 93, with regard to non-member states other than the EEA states, the court held in A that it is compatible with the free movement of capital. If a member state makes a tax exemption of foreign dividends dependent on the existence of a taxation convention with a non-member state in question, and then where that exemption is subject to conditions compliance with which can be verified by the competent authority of the member states only by obtaining information from the state of establishment of the distributing company. And paragraph 96, the court has now confirmed in its judgment in Rambo that it is in principle justified in relations with an EEA state to make the grant of tax advantage conditional on the existence of a convention of administrative assistance that enables the information provided by the taxpayer to be effectively checked. Tax exemption of EE may therefore be made dependent in principle on the existence of an agreement on administrative assistance with the state in which the company making the distribution is established. Unlike in connection with the second question, however, I consider it permissible and necessary here to examine the consistency of the national legislation in the context of proportionality. The requirement for assistance with regard to administrative matters does not relate to the discretion enjoyed by the national legislature determining what income it wishes to tax and at what level, but concerns solely a measure to guarantee the effectiveness of fiscal supervision. The question can certainly be asked in this connection how seriously the legislature has done this. It should be stated in this regard that the requirement for assistance with regard to administrative matters applies only to EEA portfolio dividends, but not to dividends from international, including EEA intercompany holdings. Such holdings are exempt from tax. However, assistance with regard to administrative matters is required neither for the exemption nor for the credit. And then goes on paragraph 101. Did not evidence, however, why there should be a difference with regard to the risk that erroneous information might be given by virtue of the size of the holding. Rather, it should be borne in mind that it would be unlawful under European law to make the general assumption that foreign portfolio holdings would be held only in order to evade taxes. The ground of justification based on the fight against tax evasion is permissible only if it concerns purely artificial contrivances, the aim of which is to circumvent tax law. Since the objective effective fiscal supervision pursued by requirements for assistance with regard to administrative matters is not pursued in a consistent and systematic manner, it is disproportionate. And so he advised that the question should be answered in the negative. We come to the court at 1208 paragraphs 53 to 54, conclusion of the court, the legislation constitutes a restriction of free movement of capital. It must, however, be examined whether that restriction of free movement of capital can be justified in light of the provisions of the treaty on the free movement of capital. And paragraph 64, he deals with submissions by, amongst others, the United Kingdom. Member state is entitled to make exemption their submission of portfolio dividends received from companies established in a non-member state to the EEA. Agreement conditioned upon the existence of an agreement for mutual assistance with non-member state concern. They state that establishment of tax paid by the company distributing dividends requires an exchange of information with the tax authority of the state in which that company is established. Follows, it should be borne in mind that case law concerning restrictions on the exercise of freedom of movements within the European Union cannot be transposed in its entirety to movements of capital between member states. And then there's an observation 66 and 67. It follows that where the legislation of a member state makes the grant of tax advantage dependent, and then we get the same passage again, essentially the same wording that I've already drawn to your lordship from Scatterved, makes a grant satisfactory in compliance with which can be verified only by obtaining information from competent authorities. It is, in principle, legitimate for the member state to refuse to grant that advantage if, in particular, because that non-member state is not bound by an agreement to provide information, it proves impossible to obtain the requisite information from it. And reference is then made to Rambo. And then at paragraph 70, even if the restriction on freedom of movement is appropriate to the objection pursued, it cannot go beyond what is necessary to obtain that objective. It must therefore be examined whether the restriction resulting from legislation such as that at issue in the main proceedings complies with the principle of proportionality. And then the answer given at paragraph 75, the answer to the first question, therefore, is that Article 63 must be interpreted as precluding legislation of member state under which portfolio dividends from holdings in resident companies are exempt from corporation tax, and portfolio dividend companies established in non-member states party to the EEA agreement are so exempt only if a comprehensive agreement for mutual assistance with regard to administrative and enforcement concerns. It's only the existence of an agreement for mutual assistance with regard to administrative matters proves necessary for the purpose of obtaining the objective of the legislation. And then I think I'm going to...
looking for here? I'm sort of lost track of this.
Sorry.
You've been through an awful lot of cases,
Yes.
and they all seem to be saying the same thing. Is there something new we're looking for here?
Well, I'd like to just deal with a point that has been made by HMRC, which says that somehow there is... Because what Haribo in fact came to the conclusion was that it could have been justified, in theory, for the legislation to have contained a restriction if it really did prove necessary.
Yeah, and that's the most recent case says the same thing.
Yes. But actually, the legislation didn't. And it was being asked the question, which is, I think, the third question, which was, is this legislation, you see that at paragraph 105, page 1217, they asked whether Article 63 precludes national legislation such as that at issue in the main proceedings. And at paragraph 131, the principle is repeated, which we've looked at so many times before, I'm not going to repeat it, paragraph 131 at page 122720. And then it goes on, however, the national legislation at issue in the main proceedings does not provide that any exemption of portfolio dividends is conditional upon the existence of an agreement for mutual assistance. In those circumstances, the difference which exists as regards cooperation between tax authorities, with the situation obtaining on the one hand between member states, on the other hand between member states and non-member states, cannot justify a different tax treatment of nationally sourced portfolio dividends. And then the answer given in 138 is that in the light of those considerations, the answer to the third question is effectively that the legislation was not compatible. Well, that's not surprising given the question that was being asked. It didn't contain any exemption. And therefore the answer to the question was, well, this legislation, as it's being put to us, doesn't contain any exemption. It might have been justifiable, is what it was saying in paragraph 131, on the principle that runs through all these cases, but it simply wasn't there. It was simply a blanket legislation, I call it scattergun approach, not focused on any particular situation where the need for independent verification, etc., would be required and can't be obtained. Not focused on that at all, simply didn't apply it. Now, it's suggested that later authorities, and in particular the recent case of X, the MBH, have shown that that approach is wrong, because you could simply do it on a matter of application. But the question before the court wasn't that. The question before the court was, is this legislation compatible? The answer is no. It could have been, but it wasn't. Now, of course, it could go back to the National Court, and the National Court could then say, well, the legislation as it stands is not compatible, but CMAR leasing, we are entitled, and indeed bound, as I think her ladyship has said, to give to the legislation a meaning so far as we can, which is in conformity with the EU. So maybe we can read into the legislation the conditions set out in paragraph 131. And that would make it compatible. But all it's actually saying in Harry, it's setting out the principle, but in answer to the question, it's saying this legislation is not compatible.
I thought perhaps the point being made in the passage you were taking us to was that in order to justify refusing an exemption on the basis that mechanisms aren't in place for necessary information to be provided, the information has to be necessary in order to verify compliance with the condition that's been laid down by law.
Yes.
And the problem here was, well, one of the problems here was that that there was no legislative requirement that was an issue.
That's the point, and therefore, whether it's up to the national state, the referring state, to determine, if I can put it, the construction and interpretation of the legislation, what the European Court was being asked to determine was whether the national legislation as presented to it was compatible. And it came to the conclusion it would have been, there were justifications, it sets it out in paragraph 131, which is up to the national state whether to read those in. Read it in here won't help HMRC, because clearly the conditions for the relief under second limb of section 23(6) do not require, at least don't require in all cases, certainly don't require in our case, do not require information to be verified by Jersey.
So you would say in your case, for example, whether Mrs. Coulter's will establishes a charitable trust doesn't require any information from the Jersey authorities?
No, none at all. All that they need to do is to look at the trust, ask themselves the question, with necessarily the aid of foreign experts in the law of the state, which the law governing the trust, is that charitable trust enforceable in this case Jersey, in the same way as a trust would be enforceable in England? Answer given, probably any Jersey lawyer would have said, yes, of course it is. Second question they have to ask themselves, well, the purpose of this trust is to provide homes for the aged in the parish of Jersey where Mrs. Coulthard lived with her late husband. Is that a purpose which under English law would be regarded as a charitable purpose? Answer clearly yes, because the relief of the aged is a charitable purpose. Nothing could be clearer. And HMRC do not dispute that. Is there any further information that we need? Answer, no, we don't need any further information. But what HMRC are in effect saying, but we are entitled to deprive the aged of the parish in Jersey,
St. Juan.
Someone.
We're entitled to deprive them of the benefit of the tax relief on Mrs. Coulthard's gift, effectively, potentially depriving them of the homes which Mrs. Coulthard intended that should be built for them, because of a possibility, is the only way HMRC, that in some cases we might have to investigate matters concerning a charitable gift, which will require us to get information from the competent authorities of a foreign country, and we might find that that information is not available. Well, there's nothing to prevent the legislation being crafted, either by direct legislation or a conforming interpretation, in the form of what we see in paragraph, was it 131, which we've just been looking at, and which mirrors the same provision as we've seen in all the other cases. So it's what we call it, we call it a scattergun approach, where the beneficiaries of Mrs. Coulter's munificence have to be sacrificed for the greater good. That's what it comes to. And they don't have to be sacrificed for the greater good, because the legislation, I mean, HMRC say, well, you've got to adopt a legislative approach, not a case-by-case approach. Well, I'm not quite sure what that entails in that. But legislation should be tailored to deal with all the cases. And is tailored to deal with all the cases if it contained a provision in form of paragraph 131 that we've just looked at in Haribo, which is similar to, not identical to the passages we've seen in other cases, containing those two conditions. Now, Velter, I'll try and go a bit more quickly now. Velter was simply a case where German law provided for a tax-free amount of 500,000 euros from inheritance tax on land inherited by a person resident in Germany, but only a 2,000 euro tax-free element if the heir was not resident in Germany. Swiss national who inherited land in Germany claimed that this discrimination was contrary to EU law. I won't take you this case to the opinion of the Advocate General. It's at paragraph 67 to 80, page 1284 onwards, that there are passages at paragraph 62 to 67 which bear reading, particularly paragraph 6, page 1297. And 63, according to the case law of the court, whether legislation of the member state makes a grant for tax advantage, and then we've seen this, it proves impossible. However, as the Advocate General has observed, the information which concerns in particular death certificates and other documents issued by civil registrars and state with can be forwarded by the heirs, or if necessary by the tax authority as part of the application of bilateral agreement for the avoidance of double taxation, and does not, as a general rule, require a complex assessment.
Do forgive me, could you just refer me to the paragraphs you want us to look at?
In the Advocate
judgment?
General's, yes, it's paragraphs 67 to 80.
In the Advocate General?
Yes, at page 1284,
yes,
electronic onwards.
I have that.
And 62 to 67 in the judgment.
62 to 67, thank you.
Yep.
Thank you.
Now, emerging markets, again, I shall now go quickly. I'm aware of time limits. Emerging markets, the question in emerging markets was whether investment funds situate in the United States should be entitled to the same tax exemptions as investment under Polish legislation. Polish legislation was available to investment funds established in Poland. And it's a case where the court, on the point that we're dealing with, agreed with the result proposed by the Advocate General, but on a but took a different route. So I shall just refer you, if I might, to what the court said you can see the question at page 1327, paragraph 17. I won't read it to you. I hope that I've sufficiently summarised the question in my introduction of this case. And at paragraphs 80 to 84, the need, perhaps I should go back to just having a look at paragraph 71 at page 1335. And said the Polish authority tax authority not in a position to determine, in the case of non-resident investment fund, that's letter E, whether it complies with specific conditions laid down by the Polish legislation, and to assess the extent and effectiveness of the supervision of that fund by comparison with the mechanism of enhanced cooperation provided for by the UCITS directive within the European Union. However, it said in relation to the argument that there is no legal instrument which makes it possible for the Polish tax authorities to check the evidence and information submitted by investment funds in the United States in order to establish whether they are comparable in nature with investment funds established in Poland, it must be stated at the outset that the mechanism of exchange of information between states set up by the UCITS directive is part of the system of cooperation established between their authorities, the supervision and investment of funds, in order to ensure that they can carry out their task, extent of their task and so on. And then he deals with that. And I'm just going to take you, I would ask you to read to yourselves at your leisure the rest of it up to paragraph 88, but I should just take you to paragraph 84. It follows from the foregoing that the justification based on the need to maintain the effectiveness of fiscal supervision can only be accepted where the legislation of a member state makes entitlement to a tax advantage dependent on the satisfaction of conditions, and then we get the same point. It's a thread running through all the authorities.
We are going to hear tomorrow an argument, at least on having read their case, we're going to hear an argument tomorrow that it doesn't matter that the revenue may not need in a particular case to verify anything, or indeed that in this case they have actually been able to verify everything they needed to verify. They say that, as I understand it, that the way proportionality works in relation to discrimination involving third countries, the member state is entitled to have a blanket rule rather than approach matters on a case-by-case basis. Now, are you going to take us to authority that deals with that particular point?
Well, the authorities that I've shown you so far all support the proposition that legislation which deals with matters on what I call a scattergun approach is not proportionate.
Well, they will argue, as I understand it, that there may be authorities to that effect concerned with member state transactions, but that the position is different when you're dealing with third countries.
Well, this is the first case you've taken us to, which deals with a third country. Everything else has either been a member state or an EEA.
Yeah, but the EEA state was really the equivalent of third country because it didn't have the same information exchange arrangements with the member states as between member states.
You'd say the case concerning Liechtenstein would be analogous to a third country.
Effectively, yes. And that was Rambo. But I think there were other ones. I think Skatovet was a non-member state, third country. Yeah.
Yes.
I'll give you a list.
All I was suggesting was...
What I'll do is I'll give you a list.
Conroy, for example, has been asking, why are we trailing through all these authorities?
Yeah.
Well, it might be helpful to anticipate the points that are going to be made against you and direct us to passages that are...
I shall be doing that, actually, but particularly when we come on to the next authority, which is Cecil.
Is there, what's the best case you've had to deal with the point that's being made against you? That's what I'm finding difficult.
Well, all these cases...
I know, but there must be a best case. And if you can't win on your best case, you don't want to win on any of the others.
Well, it starts, I suppose, with Scattervet and Stauffer.
All right, well, we can
and-
go
and
through them all
carries
over
on.
again.
Yes.
Sorry, I make the point, but
Yes.
let's carry on.
Your position, as I understand it, is that whether it's intra-member state or whether
Yes.
it's member state and third country, that a blanket requirement of an information exchange agreement is disproportionate if the information can be obtained from the donor or the recipient, for example, as in this case. Is that a fair description of?
Yes, and it's, paragraph 88 here makes it clear that the scattergun approach is not appropriate. It's necessary for the referring court to examine whether the obligations under agreements to which Poland and the United States are party, establish a common legal framework for cooperation, etc., are in fact capable of enabling the Polish tax authority to verify where it may be necessary the information provided by the investment funds, the conditions for their formation and operation, in order to determine they operate within a regulatory framework equivalent to that of the European Union. So even that, it's where it may be necessary. The burden of my submission is that what the authorities establish, regardless of whether it's a member state or non-member state, is that the scattergun approach is not proportionate. That two conditions have to be satisfied. First of all, that it's necessary to satisfy conditions for tax advantage, to obtain or verify information from a third country. And secondly, not that there is an absence of it, but that by reason of the absence of it, it is not possible to get that information. Now, in many cases, of course, it may be perfectly possible, even where there is information which is required from a foreign state, to get that information without having to trouble the authorities of a foreign state. I mean, Velta is a prime example of that. In Velta, all that they needed to get was essentially a death certificate. And although it may be right to say you get a death certificate from the authorities of a foreign state, it's generally speaking not necessary to involve a mutual cooperation agreement to obtain a death certificate. And it wasn't in that case. You simply apply to the relevant registrar and you get your death certificate.
Yes. The paragraph 84 in emerging markets, 1336, does that encapsulate your no scattergun submission?
Yes, it does. Yes, it does. And that's the thread that runs through it. Yeah. And that is actually then translated in paragraph 88 into the answer that was given. Yeah. Now, of course, there may be some cases, and Rambo was getting into that case, where it's clear on the evidence before the court that there is information which is required to satisfy a condition for tax advantage, or to dissatisfy, but it is a condition for tax disadvantage, and where it is not possible to obtain that information, which has to be obtained from the competent authorities of foreign state. It is not possible to get it. That was the premise of Rambo. So Rambo decided in that situation, yes, it may be right that in that situation you are entitled to restrict the tax advantage in that way. I think if I can get through Cecil, which deals with this point, the question it's at 333, the next divider, at page 1342. The question at issue is whether a Portuguese company should be entitled to relief from double tax in respect of dividends received from subsidiaries which it held in Tunisia and Lebanon, neither of which, of course, are members of the EU. If you go to, first of all, to 1349, Sydney at the beginning. I think it is. Yes, it's in the Advocate General's opinion. Cecil challenged the decision before the tribunal, claiming in essence that the refusal of the Portuguese tax authorities to apply the regime for the elimination of economic double taxation did not comply either with public international law or with EU law, as that regime was being applied only to the profits distributed by companies resident for tax purposes in Portugal, in member states, or the EEA, in Portuguese-speaking African countries, and in Timor-Leste. According to Cecil, that difference in treatment with respect to profits from Tunisia and from Lebanon infringed both agreements as well as Article 49 TFU and 63. It's Article 63 we're of course concerned with. If you go to the judgment, page 1387, in the present case, the tax legislature, I'm so sorry, it's page 1387, paragraph 61. In the present case, the tax legislation at issue in the main proceedings excludes in general terms the possibility of avoiding or mitigating the economic double taxation of dividends where such dividends are distributed by companies established in non-member states, and does not seek specifically to prevent conduct involving the creation of wholly artificial arrangements which do not reflect economic reality, with a view to escaping the tax normally due or to obtain a tax advantage. And so it concludes you can't justify the restriction on any need to prevent tax fraud and evasion. And then it goes on with, as regards in the second place, the need to ensure the effectiveness of fiscal supervision, it should be pointed out the movements between member states and non-member states fall within a legal context different from that in force with the Union, and that the framework for cooperation, as amended by various directives, etc., on administrative cooperation in the field of taxation does not exist between those authorities and competent authorities in a non-member state. It is a court-settled case law that, therefore, where the legislation of a member state makes a more... And then we get the same rubric, which is repeated. So we're dealing here now with a non-member state. In the present case, it's clear from Article 46 that where both the distributing company are resident in Portugal, the full deduction of dividends from taxable amount is permitted, where the distributing company is subject to corporation tax. Pursuant to Article 46.8, in the event, this is of course of Portuguese law, in the event that the conditions to which the beneficiary company is subject are not fulfilled, then in order to qualify for the partial deduction, the condition that the distributing company be liable must also be fulfilled. It may therefore be considered entitlement to the full or partial deductions provided for in the articles is dependent on satisfaction of the condition of tax liability of the distributing company, which the tax authorities must be in a position to verify. And then he refers to various conventions between Portugal and Tunisia. It's for the referring court to examine whether the obligations under those conventions are such as to enable the Portuguese tax authorities to obtain from Tunisia information which would allow them to verify the satisfaction of the condition. Since, as the referring court has stated, no mutual assistance convention has been entered into between Portugal and Lebanon, the refusal to grant the full or partial deductions may be justified by the need to ensure the effectiveness of fiscal supervision if it proves impossible to obtain information from the Lebanese Republic, allowing it to be verified whether the condition related to the company distributing the dividends being subject to tax is satisfied. It should also be noted, however, that under Article 46.11, deduction referred to in Article 40 of that code is reduced by 50% when the income comes from profits that have not actually been taxed, unless the beneficiary is a capital share management company. It is for the referring court with sole jurisdiction to interpret national law to determine whether that provision can be applied in situations where the liability to tax of the distributing company in the state of residence cannot be verified. If so, the overriding reason in the general interest, based on the need to ensure the effectiveness of fiscal supervision, cannot be relied upon to justify the restriction resulting from the refusal to grant the partial deduction provided for the article in the case of dividends originating in Tunisia and Lebanon. And then, in the light of the foregoing consideration, the answer to the 11th and 12th questions is that Article 63-65 must be interpreted as meaning that companies
So
established...
which one are you relying on? We've been through all this time and again. I mean, the point here is it's not very easy, or may not be very easy, to get the information from Lebanon, but nonetheless, you would say, well, the question is whether, as a matter of fact, it proves impossible.
I'm relying on the third finding,
Yeah, I can understand
72.
that. But I mean, we don't need to read it all again.
The refusal to grant a full or partial deduction, instead pursuant to the articles, may be justified based where it proves impossible for the tax authorities.
But otherwise not, is
That's
the
what
point
we
in
are.
71.
And we are now dealing with
Yes.
third countries, not in a member
You say
state.
in case of Jersey, it hasn't been proved it's impossible.
And incidentally, one of the countries, you will have seen paragraph 69, I read that to you, Lebanon, did not have any exchange of information agreement.
No, and in the case of the other one, Tunis, they look at the agreement to
Look at
see
the agreement.
how
I mean,
effective it is.
Against Tunisia, the answer is, well, it's legitimate to refuse the tax advantage. If it proves impossible, the tax authorities of the member state to obtain information from the non-member state in which is resident, allowing those authorities to verify whether the condition of the later company be subject to tax is satisfied.
Well, Mr. Steinfeld, you've reached beyond 4 o'clock. We stopped listening at 4
Yes.
o'clock.
I wasn't going to say anything more, except to say that apart from the ex-GmbH case, which I'll deal with briefly as I can tomorrow, I have dealt with my trawl through the EU authorities.
It might be helpful, I mean, reading again the Revenue's case, they are founding very strongly on Rambo.
Yes.
And it might be helpful if you just said a word tomorrow about why you say, I presume you say, that they are taking what's said in Rambo out of context.
I will do that. I dealt with it, but your Lordship is right to remind me, and I'll come back tomorrow on that.
Thank you. Well, we'll look forward to that.
Uh,
We'll see you tomorrow morning. Adjourn now.